Welcome to the Aiken-Gump-Kenrich webinar on navigating COVID-19 federal funding and assistance, accounting and legal issues. We are glad to have you here with us today. I'm Angela Stiles. I'm a partner in the Aiken-Gump Washington office. I am joined today by Chelsea Cullum, Jeff Duvall, and Greg Bingham from the Kenrich Group. Chelsea, Jeff, and Greg are accounting and finance consultants who specialize in assisting government contractors. Much of their work involves the quantum portion of requests for equitable adjustments and claims, expert witness testimony, forensic accounting and fraud investigations, and assisting contractors with government accounting compliance. From Aiken-Gump, I am joined by Kelly Cleary, a healthcare partner in our Washington office. Kelly recently rejoined us after serving as the Deputy General Counsel of the Department of Health and Human Services and the Chief Legal Officer for the Centers for Medicare and Medicaid Services. We are also joined by Bob Huffman and Scott Heimberg, government contracts partners in our Washington office. Welcome, everyone. We look forward to the next hour and a half. If you have any questions during or after the presentation, please do not hesitate to contact us. Our emails and phone numbers are included at the end of the presentation. So let's get started with today's agenda. Chelsea and I are going to kick this off with a discussion of accounting and legal issues surrounding several of the new funding vehicles, including Section 3610 of the CARES Act, the Paycheck Protection Program, and Main Street lending. Greg Bingham is going to cover claims and REAs, which will include a continuing discussion of Section 3610. The Defense Production Act and Biomedical Advanced Research and Development Authority, or BARDA contracts, will be covered by Scott Heimberg. What to expect for oversights, audits, and investigations will be covered by Jeff Duvall. And finally, Bob Huffman will close out our presentation with a discussion of False Claims Act issues that you should keep in mind as you're considering all of these programs. But let's start with what's new. Accounting in the time of COVID-19. Between the Paycheck Protection Program and Main Street lending, there are literally millions of companies and new companies interacting with the federal government, receiving funds and loans from the federal government for the companies that have never worked with them before. If it were only as easy as filling out the application, receiving the funds, receiving forgiveness, or paying back the loan, this would be a lot easier discussion than we're having today. But for those of you that are new to this federal funding world, we're going to walk you through some of the basics of legal and accounting issues to keep in mind, particularly when you're dealing with the Paycheck Protection Program, Main Street lending, and the CARES Act Section 3610. For federal contractors, the concept of potentially being paid for workers on your payroll and subcontractors that are not able to access their work site is a new concept, and frankly fraught, I think, with a great deal of certainty as well. So let's start with the CARES Act, Section 3610. In a fairly unique move, Congress added Section 3610 to the CARES Act, stating that agencies could, and I'm going to emphasize could, pay contractors and subcontractors for employee compensation for work that cannot be performed at, quote, government-approved work sites during COVID-19 closures or other restrictions where their job duties cannot be performed remotely. Sounds great on its face. The problem is Congress didn't appropriate additional funds to cover those payments. So while a contractor might get paid for employees and subcontractor employees that were not able to access the workplace and could not actually work from home, at the end of the day, the agency may actually not have enough money to both pay for that work as well as fully fund the program. The money has to come from somewhere. And what we've noticed is that there have been significantly different reactions from different agencies. GSA, for example, has come out and said, we don't have the money, we're not going to do this. It's going to be a really unusual situation if we approve 3610 funds. DOE, on the other hand, has consistently been working with the national labs to cover the cost of prime contractor employees and evaluate subcontractor employees that should be paid and to also find the money. DOD, the Department of Defense, has issued a class deviation and guidance. Much of it is targeted at cost reimbursement contracts, but they also state they're going to need an REA for firm fixed price contracts. I think the big question is DOE going to be able to pay for these costs? Are other agencies, DHS and other agencies that have said they're looking at this, actually going to be able to pay for the cost? Certainly our advice on this is to talk to your contracting officer early and often. And I think, as you'll hear from Chelsea, there's some other strategies and some accounting issues to also take into consideration as you're evaluating these costs and determining if you can be reimbursed for them. But Chelsea, I'll turn it over to you.
Thanks, Angela. So, yeah, I just wanted to talk a little bit about the strategy considerations surrounding potentially accepting funds under the Paycheck Protection Program. Now, if you're a government contractor and you have a mix of cost reimbursement contracts and firm fixed price contracts, it's worth analyzing which contracts should bear, or which contracts to which you will allocate the proceeds of those funds. So, for example, if you have a firm fixed price contract, it may be more profitable and advantageous for the company to actually pay the employees who work directly for a fixed price contract with the PPP funds. But it's important when doing that to remember that, as Greg Bingham will talk about a little bit later, to make sure that you're accounting for those costs very clearly, because what you don't want to happen is to claim costs in an REA later on that you've already been reimbursed for through the PPP. And so that's just one of the sort of strategy considerations, but it bears repeating that if you are a contractor looking at taking these funds from the government, analyze, the best way to use them, because there may be several different scenarios that could impact the profitability of your company. So shifting gears a little bit, Ellen Lord, who is the Undersecretary of Defense for Acquisition, testified before the House Armed Services Committee on June 10th about the potential impacts of 3610 to the Department of Defense contractors. And so she referenced one major prime contractor that estimated the 3610 impact could be up to $1.5 billion for their company and associated suppliers. And that contractors will be able to seek Pentagon reimbursement for COVID-19 related costs associated with government-directed stop work orders, purchase of PPE, cleaning and sterilization costs, and some other things. One thing I wanted to mention here that was an example back in April that wasn't covered by what Undersecretary Lord said, but is worth sort of exploring, is that, and this is just one example, at the Norfolk Naval Shipyard in April, 40 General Dynamics workers failed to show for some shifts in protest of working conditions after a colleague died of COVID-19. And so, as you can imagine, that causes significant disruption. And, in addition, there are working on ships in close quarters, the potential of getting COVID-19 increases. So the impacts from those types of events will be felt as well. And there's a couple different ways to sort of think about this. One is from the prime contractor standpoint. So if you think about the General Dynamics of the world and those large contractors, well, you might think, well, they can absorb that disruption better than some other companies. But where this is really going to be felt is in the ripple effect up from the smaller tier, lower tier subcontractors that are small and medium-sized businesses. Maybe they are manufacturing components and they had to shut down their manufacturing lines as part of the overall shutdown that lasted from March until early in the summer. So those impacts, and especially on those small and medium-sized businesses, which may not be able to reopen, are going to create additional layers of disruption that will undoubtedly result in additional claims and REAs that will flow up to the government through the prime contractors. And now I'm going to turn it back over to Angela for the next slide.
Thank you so much, Chelsea. And I think it's very interesting because it's probably a lot more clear for some of the prime contractors in their discussions with contracting officers, and a lot of them that I've been dealing with at the Department of Energy, whether they're going to be reimbursed under 3610, not as clear as you were saying for the subcontractors in the lower tiers that in many ways were probably substantially more impacted by, shutting down their manufacturing facility as well, and may never be able to receive that money. So it's going to be a very interesting dynamic, I think. So now let's move to the Paycheck Protection Program. Speaking of a lot of money that has actually been appropriated, part of the CARES Act was the Paycheck Protection Program, and Congress appropriated $650 billion to a forgivable loan program for businesses of less than 500 employees or hotels and restaurants with less than 500 employees per location. You've probably heard a lot of controversy about this program, but it has been incredibly successful, keeping employees on the payroll that might otherwise have gone on the unemployment rolls, or encouraging companies to rehire their employees. As of June 12th, the SBA has approved over 4.5 million PPP loans, totaling more than $512 billion that have come through more than 5,000 lenders. It also means that there is about $140 billion left in the program as well, so it's going to continue on for a little while. The loans cover 2.5 months of payroll. That's how they're calculated. They are largely forgivable loans as long as you're using 60% of the proceeds for payroll and you're keeping your employment and your compensation level stable for a period of time. To the extent that they're not forgivable, it's a 1% loan for between 2 and 5 years, depending on when you received the loan, whether that was before June 6th or after June 6th. Principal and interest can be deferred until after the SBA makes a decision on forgiveness, and you have 10 months actually to submit that forgiveness application. There have also been some recent legislative improvements to the Paycheck Protection Program. It was enacted very quickly. PPP was done very quickly. Nobody knew at the time what was going to happen, how to address this, how long it might take for businesses to get back to close to full employment. And most significantly, the original PPP under the CARES Act only measured forgiveness for the 8 weeks after loan disbursement. And as it turns out, what we thought in March was going to be a short period of shutdown has turned into a much longer period of shutdown. So the PPP Flexibility Act actually extends that period of forgiveness to 24 weeks after loan disbursement. Or if you were able to keep your people employed during that 8 weeks, you could also use the 8-week period. Very, very important for you to take a look at which one you want to use. One may actually be a better period of time for you, whether it's 8 weeks or 24 weeks. So if you applied before June 6th of this year and you received your loan before June 6th, you're going to have the option to use that 8 weeks or to use that 24. One will be definitively better than the other for you. So what's going to happen in terms of government review and government audit of PPP in particular? So of the 4.5 million loans, the average loan amount was $112,000. SBA is not going to scrutinize very heavily the smaller dollar value loans, which represent the vast majority of the loans. They have been very clear that they're going to give a lighter audit touch to loans under $2 million. The lender actually is the point of first approval. So if there aren't any significant issues with your application, whether it's how you calculated forgiveness, how you calculated the original amount of the loan, your eligibility through affiliation, or whether you're a business that might not be eligible, your certification of need, below $2 million, those might be scrutinized more closely. But as a general rule, as they've stated in their interim final rules and their FAQs, they're going to rely on the lenders to approve forgiveness for the loans below $2 million. So you'll fill out a loan application, a loan forgiveness application, and the lender will have 60 days to approve or disapprove and let SBA know. Once the lender approves, it does go to SBA for an additional 60 days of review. But it's going to be the larger dollar value ones at the end of the day that they're going to be taking a closer look at.
And Angela, I just wanted to jump in here quickly and put into context what we mean when we say, that they're going to be reviewed, audited, looked at. I think a lot of people, especially, medium-sized and smaller-sized companies who aren't familiar with government auditing practices, or, the exposure that they have to accounting is primarily through financial statement audits, this is going to be fundamentally different. And so when we talk in a few minutes about what is going to happen in these audits and sort of our recommendations for how to prepare for those audits, we're really focused on cost accounting, and that is really in turn focused on the traceability. So how did you actually spend the money that you received from those loans?
Thank you, Chelsea. And now we're going to turn to the last new program under this section, Main Street Lending. We don't know as much about Main Street Lending. It just opened for applications on Monday of this week. It's run by the Boston Federal Reserve, although Congress and the Department of Treasury have been very active in putting together these programs. They recognized that it wasn't just businesses below 500 employees or restaurants and hotels that needed help. They wanted to make some loan facilities available for other businesses, small and medium-sized businesses. They've created 3 different lending facilities. They have a lot of details up on their website about these facilities. They range from $250,000 to $300 million. The principal is deferred for 2 years, and then interest payment is deferred for 1 year. Eligibility, you had to have been in business by March 13th of this year. You cannot have more than 15,000 employees, and the standard affiliation rules apply. So if you have a parent corporation, if you're owned by private equity, if you have other affiliates, you're going to have to look at those to see if you're actually less than 15,000 employees. You can also not have more than $5 billion in 2019 annual revenue. And again, the affiliation rules apply. You're going to have to aggregate parent and affiliated company revenue to determine if you're eligible. There's also a list of ineligible businesses that runs from everything from lobbying firms to strip clubs. And I only mention strip clubs because there's already been some litigation in Michigan about the eligibility of strip clubs for the Paycheck Protection Program as well. So even these rules on eligibility of businesses are under some, significant litigation attack, if you will, about whether they are appropriate or not. And finally, if you're thinking about the Main Street Lending Program, make sure you're looking at all the conditions and the certifications required. There are a lot of companies that have decided that the conditions, certifications, and the interest rates are not worth actually taking the Main Street Lending facilities. So with that, I'll turn it over to Chelsea to talk about accounting for these funds.
Thanks, Angela. Yep, so I'm going to switch gears a little bit and talk more about the nitty-gritty, the accounting piece that us accountants really like, but the attorneys don't as much. So one thing that we wanted to call out is the CARES Act incorporates the Hhs Cost Principles, and they are similar to the FAR Part 31 Cost Principles. And so for anybody who is not familiar with the FAR Part 31 Cost Principles, they define what an allowable cost is. And again, Greg Bingham later will get into, and Jeff Duvall will get into a little bit of the concept of allowability. But the easiest way to think about allowability is it's what the government is willing to reimburse. So for example, the government is not really willing to reimburse contractors for alcohol. And so these cost principles and what may be allowably claimed under these loans, government auditors typically look to these cost principles to come up with their audit opinions. And so as they're auditing the costs and auditing the way that contractors use these loans, they are likely to refer to the Hhs Cost Principles and the FAR Part 31 Cost Principles to guide their audits. And so, as I mentioned a minute ago, companies really should maintain full traceability of all the funds accepted under assistance programs. Now, what are some concrete steps that can be used to do that? So just a few suggestions here. One is put loan proceeds into a separate dedicated bank account. That's going to make all the transactions easier to trace if they're centralized in one place. Another recommendation is to create a separate cash account in the financial books and records specifically to trace loan proceeds. So again, this idea of centralizing and organizing the records is going to make things a lot easier when the auditors come calling and looking for information. Now, in terms of supporting documents, what types of supporting documents do contractors need in order to support that the costs were, that the loan proceeds were spent in a manner that is consistent with the legal stipulations? Sometimes those are payroll records, timesheets, any budget and forecast data related to headcount. For non-payroll expenses, those tend to be sort of receipts, journal entries used to record the expense, including descriptions. And again, we would recommend to the extent possible that these are centralized and organized so that if you put in that effort to organize things on the front end, that makes the audit process a lot easier and a lot smoother, and the contractor is more likely to recover or to not get any adverse findings if the documentation is clear and substantial. And so with that, I will turn it over to Greg Bingham, who will talk a little bit about claims and requests for equitable adjustment.
Thank you, Chelsea and Angela. It's very informative. I'll just say a little bit about the mechanics or how one prepares an REA, that's request for equitable adjustment, to the government, or a claim if it's between a prime and a sub or something of that nature related. And I'll focus on labor productivity. There are lots of categories of cost that can be increased due to changed specifications and contractors having to perform work differently than they had anticipated. But with the stories that I'm hearing about the impact of COVID-19, I think they're more related to labor productivity, additional labor costs and poor labor productivity. So I'll focus my examples there. As you can see on the slide, there are many implications of COVID-19 that may lead to REAs and potentially claims that are outside of the purview of the CARES Section 3610 and the reimbursement associated with 3610. As a reminder, Section 3610 of the CARES Act allows agencies to reimburse at certain minimum contract billing rates any paid leave, including sick leave, a contractor provides to keep its employees or subcontractors in a ready state. So the claims are likely to arise from COVID-19 are going to be more, as I said, labor productivity than other things. And so here are some examples: loss of productivity, change in working conditions, rescheduling of planned work, less than optimal work sequencing, less than optimal work methods, congestion in the workplace. So think about social distancing and think about it. So some of you may be in a professional services area where you can work remotely, and so keeping the social distancing is not a problem. But think about many other types of work, and some examples that I've heard recently for, say, an M&O, management and operations contractor for the DOE, who said they had hundreds of suppliers and they anticipated getting REAs or claims from virtually all of them. And so why would that be? Well, they commented that there is at least the backup at the gate where the workers are trying to get into the facility, and they have to be spaced out to keep the social distancing. They have to have their temperature checked before they can go in. They have to don their personal protective equipment. And at the end of the shift, they have to have their temperature checked. They have to remove the PPE. And then during their whole shift, they can't work close to someone else, which is their typical way of doing things. So it affects productivity. That was for an M&O contractor. And you think there are many different areas where working close to someone is the norm, and because of social distancing now, you really can't do that. And so cause and effect is something to keep in mind when you're creating an REA or a claim. And it's a typical failure that contractors experience when they think about what's the impact, but they don't tie the impact/cost, extra hours, extra cost. They don't tie that back to what caused it. So think about this chain when you're preparing an REA or claim. What is the required statement of work? What's the causal event? What's the resulting impact from the causal event? And then what is the cost or the delay associated with that? And at the far left here, what's the required statement of work? You could say to yourself, well, what was included in the bid? What is the specification that you're to perform to? What's the performance work statement? What's the statement of work? And there, it's think in terms of the minimum required by the contract. In other words, you don't, sometimes, especially engineers, and I'm an engineer by training, especially engineers will say, well, that's the way we should have did it. That's the way we should be doing this, as opposed to what is required by the contract. And I'm not saying that contractors can't volunteer work, but you don't want to volunteer work without it getting management approval. You don't want management to think that something is required by the contract that is not really required by the contract. So think in terms of the minimum requirement of the contract, and then what was the impact to go above the minimum requirement of the contract. And I'll just pause to see if counsel wants to comment on that, because I think they have likely seen similar circumstances. And with no comment, let's go on to the next slide. And so for labor claims, we can focus on labor claims. They should typically be based on actual project experience, based on contemporaneous objective evidence, reflect actual productivity information and actual labor rates, as opposed to like change order rates. It needs to reflect cost. And for us accountants, there's a big distinction between cost and price. And so cost is, in your cost accounting records, what something actually cost you to do it. Price is what a rate you may have developed that may have some profit embedded in it or something of that nature, where we for REAs, the requirements in FAR 15 and FAR 31 are that it be based on cost. The next slide, I'll just talk a little bit about a few different techniques. So with the graphic that we have on the screen now, labor overrun components, it's kind of a useful way to look at labor cost overruns or labor dollar overruns. So there's hours and there's dollars per hour. And the vertical axis is dollars and the horizontal axis is hours. And you can see the blue box at the bottom left, that's the budget, which was $25 an hour times 5,000 hours equals $125,000. So that's the budget the baseline that you compare against when you're developing the REA. Then you're trying to figure out, okay, what's the overrun or what's the cost growth and what caused the cost growth? Well, in this instance, you can see that the green vertical bar, the quantity variance of 120,000, that's 4,000 hours, 9,000 minus 5,000, or 4,000 hours times $30 an hour. So whatever caused you to increase the quantity of hours by that 4,000 hours, that's responsible for the green bar, the quantity variance. Then there's a productivity variance, where to get the same work done, you had to incur an extra 1,000 hours because of just poor productivity. And that could be social distancing or something of that nature. And that's 1,000 hours, that's the far right, 1,000 hours times $30 an hour, or $30,000. And then there's a wage variance on the original budget, which is just you had to pay higher wages at $30 an hour than were anticipated, which is $25 an hour. So this is a good way to think about overruns or cost growth, so that you can orient yourself to figuring out what did the government or the customer cause you to incur extra, or in what way did the government or the customer cause you to incur extra hours, and what's the dollar amount of those hours? So on this slide, I'm going to talk about what's become a relatively famous quantification method, and it's called measured mile. And so you can go to boards of contract appeals or court of federal claims or federal district court decisions where for quantum, the measured mile is used, and you can hear what judges have to say about the acceptance of the measured mile approach and what it takes to be acceptable. In this example, I've got a vertical axis, which includes man-hour per linear feet, and the horizontal axis has got different time periods, period 1, period 2, period 3. And in the contractor bid 0.75 man-hours per linear feet. Period 1, they achieved 1.13. Period 2, 1.0. Period 3, 1.36. In my example, period 3 is when COVID-19 hit. So that's when the productivity got worse. And a claim or an REA might be based on the difference between period 3, when COVID-19 was impacting performance, and period 2, when COVID-19 was not impacting performance. So the difference between 1.36 and 1.0, or 0.36 man-hours per linear feet, can be used in the calculation to determine the additional labor costs associated or caused by COVID-19. The government, so we're talking here about change order accounting, and there is this clause at 52.FAR 52.243-6 related to change order accounting. And even when this clause is not included in a contract, it's become part of the lore, if you will, of government contracts, that the reviewing party, the government, for example, receiving an REA or claim, says, well, did you use change order accounting? And if you didn't, why didn't you? And so it's often an item of debate about the use of change order accounting. And what is change order accounting? It is the idea that when a change happens, a contractor is forced to do something in addition to what they had planned to do, that they set up charge accounts, special accounting codes, and then all of the hours and effort associated with that extra effort and that extra work they have to do, they record that to the special charge numbers. And then fast forward a year later, and they're putting together an REA, they just go to this accounting code and they say, here, we recorded all of our efforts real time to this accounting code. It's not, when it makes the proof of the REA amount much more straightforward. It is not often feasible to do this, but when it is feasible, you should do it. And so this is something to think about, especially, we're talking about COVID-19, especially with regard to COVID-19 impacts. Are there ways to set up these codes and record the extra effort to these codes? It's a good idea if you can. And then the next slide, I'm just going to talk kind of a wrap up to talk about some common pricing challenges, and that is double counting between different claim elements. Be very careful about that. In proposals on new work and in most areas of accounting, it's easy to avoid double counts. Things are set up to avoid double counts. With REAs and claims, because of the estimating techniques that are used, it is a possibility. So you have to be very cognizant of it, and you have to work to make sure you've avoided and eliminated any double counting. Double counting could be, as Chelsea mentioned earlier, could be between costs covered by PPP loans and REAs. You wouldn't want to attempt to recover the same funds through two different places. That would be inappropriate, of course, so that's a double count to look for. Another common pricing challenge is improper baseline. You can have, if your baseline is too high, then you've got an understated claim. If your baseline is too low, you've got an overstated claim. Getting the baseline just right is important, and this is a classic thing for government auditors to review. All the things on it, if the Defense Contract Audit Agency or some agency, Inspector General, or others are auditing your claim, these are classic things to look for. And then lastly, no linkage between entitlement and pricing. That's the cause and effect that I started out talking about. There needs to be this strong causation or cause and effect tie. And with that, I'm going to pass it on. Thank you.
Well, thank you very much, Greg. I'm Scott Heimberg, and I will be discussing the Defense Production Act, which is commonly referred to as the DPA. The DPA has been around since the Korean War, but only recently has it become somewhat of a household term, at least if your household includes government contractors or manufacturers of healthcare products. When the COVID-19 crisis started and it appeared that there would be a shortage of personal protective equipment, or PPE, along with ventilators, certain members of Congress were calling for the president to use the DPA to meet the increased demand from hospitals and elsewhere. And President Trump was initially reluctant to use the DPA powers available to him, but later appeared to have embraced them as the crisis deepened. So what powers are available under the DPA during a national crisis that threatens national security? The DPA grants several separate and distinct authorities to the executive branch, meaning the president, to ensure that domestic industries can meet national defense requirements, including the ability to require companies to prioritize defense production, which is under Title I of the DPA, or require companies to allocate defense production, which is also under Title I. The DPA also provides economic incentives to secure domestic industrial capabilities that are essential to meet national defense requirements, and that is under Title III of the DPA. And finally, the DPA also establishes that government agencies and the private sector can enter into voluntary agreements and plans of action to help provide for national defense, and that's under Title VII of the DPA. So, under Title I, Section 101 of the DPA, the President is authorized to require the acceptance and performance of contracts for the federal government and to prioritize such contracts over performance under any other contract. And we're going to refer to this as the prioritization prong. And as I said before, Title I also gives the President the powers to allocate materials, services, and facilities in such a manner and upon such conditions and to such extent as the President shall deem necessary or appropriate, which is called the allocation prong. And we're going to talk about that shortly. The government orders take precedent over commercial orders under the prioritization prong. And contractors that receive rated orders or orders under the DPA are provided protection from breach of contract suits from commercial customers if the government priority causes late commercial deliveries. So in other words, the government says they want a widget, the widget's already been promised to the commercial customers, and the government says, no, I need the widget now, my order takes priority over all other orders under a rated order, then the commercial customer is not going to get its widget in a timely manner and would otherwise have a breach of contract action against the manufacturer. But under the DPA, if the contractor received a rated order from the government and was forced to prioritize the government's order over all others, the commercial customer no longer has a cause of action against that manufacturer, and the DPA provides that protection as the manufacturer provides the widget to the government. So this has really been seen more under Department of Defense contracts than any other contracts previously. So for years, defense contractors have received rated orders from Department of Defense in the various Department of Defense agencies, and they're commonly seen as DO or DX rated orders, which gives the government priority in times of war or other crises where the government needs the product sooner rather than later. The government, as I said, has been using this in the DoD context, but is only newly using it in non-DoD contexts. So now with the COVID-19 emergency, we are seeing medical service device companies and other healthcare-related manufacturers receiving rated orders in response to the pandemic. And these are typically companies that may have been doing business with the government but have never received a rated order before from the government. Specifically, manufacturers of ventilators and respirators have received rated orders from the Department of Health and Human Services. We also are seeing this in the vaccine area most recently, with Emergent signing a contract with BARDA that gives the government priority to have Emergent mass-produce the COVID-19 vaccine when and if directed by BARDA, even though Emergent already had commercial agreements with several vaccine developers to produce that product. So whoever comes to market first with the vaccine under their BARDA contract, BARDA is going to turn to Emergent and require Emergent to manufacture that vaccine as ordered by BARDA over the other commercial development that may be taking place by other vaccine developers. So under the DPA, a contractor that receives a rated order must flow down the clause to its subcontractors and suppliers to ensure that its supply chain is providing the products that are needed in order to manufacture the goods that are being needed in the emergency situation by the government. Newcomers to rated contracts have not really thought about this before and need to modify their existing supply chain agreements to get suppliers to give the same priority to government orders that the manufacturers have agreed to with the government. This has created issues with U.S. manufacturers, and especially with foreign suppliers who are being dragged into conflicting priorities, as other governments also are looking to those suppliers to give their own countries' needs priority over the U.S., or at least priority over other countries. So there's a conflict that's been set up between the U.S. demand and demand by other countries that have similar needs. So the other prong, as I said, is the allocation prong. And this is perhaps the scariest of the DPA authorities for companies in the private sector, as it provides the authority to direct allocation of manufacturing resources and also direct product in the marketplace. The allocation prong is written in a very broad manner and can be interpreted to allow the president to order a manufacturer to produce needed equipment or redirect product that's already in commerce. Recent executive orders and presidential memoranda issued in response to the COVID-19 pandemic represent the first time that the U.S. government has invoked or used the allocation prong that's available to the president under Title I. And in particular, on March 27th, the president issued a memorandum on order under the DPA regarding the purchase of ventilators. And under that memorandum, the president authorized the Secretary of HHS to use any and all authority available under the DPA to require GM to accept, perform, and prioritize contracts or orders for ventilators. And what's particularly noteworthy, as I said, the DPA has been used before with typical government contractors and specifically under the Department of Defense contracts. But here, this is at least one of the first times a product that has really not been manufactured by a company is being ordered to be manufactured by a company. So GM does not normally manufacture ventilators, but here the president was really applying pressure to GM to enter into an agreement to manufacture the much needed ventilators during the crisis. And it was really used more as a lever or coercion to get GM to come to the bargaining table and accept the terms and conditions that the government wanted GM to agree to. GM was, in the midst of negotiating the agreement at that time, and the negotiations were dragging on, or at least so the president thought. And so, he went public with the demand for GM to manufacture the ventilators, and it worked. In this case, GM the next day agreed to begin manufacturing of the ventilators under the agreement that the president was looking for. The president also used the allocation prong to secure scarce or threatened health and medical resources for domestic use. On April 3rd, he issued a memorandum doing just that, which he said was there to restrict the export of personal protective equipment from being exported by manufacturers and other people who are holding that type of equipment offshore. And on April 7th, FEMA issued a rule prohibiting the shipment of 5 categories of PPE from the U.S. And really, that is the first time that I'm aware of that the president has reached into the stream of commerce and disrupted that stream to make sure that product was kept in the U.S. rather than sent to for sale abroad. And this was really created a lot of confusion in the marketplace because companies just weren't used to seeing that. And the rules that were issued by FEMA, I think, also created confusion regarding what could be exported and under what conditions, and things had to be pulled back from the normal stream of commerce. So we also mentioned that there's a Title III to the DPA, and under Title III, the President is granted the ability to expand U.S. Production capacity of products that are needed for national defense. And that's a very broad term, and it includes, as I said, the medical devices and PPE that's needed to address the COVID-19 crisis. So using the Title III authority, the President may issue loan guarantees and direct loans to reduce shortfalls of product that are needed in the U.S. and provide other financial incentives for domestic industry to produce and supply essential goods, including through making direct purchases, providing subsidies, and also government sponsorship of research and development activities in the U.S. The Department of the Air Force is one agency that's been given authority to find ways to increase U.S. manufacturing capability of essential products, which has led to agreements to increase domestic PPE manufacturing capacity in the U.S. The U.S. government also has awarded a contract worth as much as $800 million to increase domestic pharmaceutical manufacturing. Currently, most active pharmaceutical ingredients come from China or India, which has received a lot more attention during this crisis, and we're going to talk a little bit more about that in future slides. Finally, there's authority under Title VII for the President to enter into agreements with private industry. These are voluntary agreements to look at preparedness and plans of action during times of crisis and to increase national defense. So where the government and the private sector enter into these voluntary, quote-unquote, voluntary agreements, the regulations under the DPA establish that, one, there has to be a federal sponsor for those agreements. There have to be public meetings that are held to develop the agreement so everybody is aware of what agreements are being entered into and who's participating. And the agreement participants must be reasonably representative of the appropriate industry or segment of the concerned industry. And then for those companies that do enter into these voluntary agreements, there are some protections. So normally gatherings of individuals who represent competitors don't usually get together to discuss how they're going to produce product for sale to customers and the pricing of those products because of antitrust laws. But under the DPA, there are some antitrust protections that companies are given if they do voluntarily gather together to discuss these things under Section 708 of the DPA. There's also some protections for breach of contract. Under Section 708, there's defense allegations of breach of contract in state and federal court for breaches caused predominantly by action taken during an emergency to carry out a voluntary agreement or plan of action. So Peter Navarro, who is the Director of Trade and Manufacturing Policy and is now also the National DPA Policy Coordinator, has long sought increased production in the U.S. And tried to get government agencies to buy American. The COVID-19 crisis, I think, has created an opportunity to look at that again and to see what executive order could be put into place to increase U.S. production and to decrease purchases from foreign manufacturing. So there is a possible executive order that could be issued. We expected it to have been issued a few weeks ago. I think it's still under consideration by the President. But the terms of that executive order have been leaking out slowly, and it may or may not look like what we're talking about now, but I think it's going to have, if it does come out, many of of what we have listed here as elements of that executive order. So I'm not going to read all of them, but it will include onshoring of manufacturing for essential pharmaceuticals, which has already started to take place, ensuring long-term demand for domestically produced supplies by creating government demand for companies that will agree to move manufacturing back to the U.S. or create new manufacturing in the U.S. Maximizing domestic production capacity for those items that are needed for public health and national defense purposes. And in particular for government contractors and for people who are in the government contracting space, like us lawyers, requiring that federal departments and agencies limit procurement of essential pharmaceuticals and medical supplies to those manufactured in the U.S. and look at altering free trade agreements that the U.S. government has already entered into previously to exclude coverage of essential pharmaceuticals and medical supplies within perhaps 30 days of the date of the order, which would be a very, very quick turnaround where the supply chain would essentially have to move back onshore to the U.S. and away from countries that were participants in trade agreements with the U.S. The possible executive order or proposed executive order that's out there will also or could also require DoD to rescind any procurement preferences for essential pharmaceuticals and medical supplies from quote unquote qualifying countries, which is a DFARS term that's used for countries that have entered into agreements with the Department of Defense that allow the supply of those products from those qualifying countries to be treated as if they were made in the U.S. The order could also require HHS and the FDA commissioner to identify supply chain vulnerabilities to, again, increase U.S. Manufacturing of those supply chain products, and authorize HHS to utilize the DPA, which we have been talking about, both the prioritization and allocation prongs, to make sure that the product is available in the U.S. And then also the executive order is looking at streamlining the requirements that are looked at to create new manufacturing. One of the holdups has been requirements under the EPA, and this executive order would look to either do away with or severely limit the EPA regulations that slow down new manufacturing and new construction. So, as I've been saying, the initial focus is on pharmaceutical supply chains and production, but the executive order, I think, is going to go beyond that eventually. On May 11th, Director Navarro called out the Department of Veterans Affairs, DoD, and HHS as key agencies that should be buying American, and that the administration is going to deregulate so that we can actually locate pharmaceutical manufacturing in the U.S. And then he also noted that none of the Buy American provisions in the proposed executive order would apply during the COVID-19 crisis, the current crisis, but is intended to apply soon thereafter. And with that, I'm going to pass it over to Kelly Cleary to discuss the CARES Act and HHS relief for hospitals.
Thank you, Scott. I am going to be speaking about some of the emergency funding and regulatory relief that is specifically directed at healthcare providers who are no strangers to federal programs. HHS has sought to act very quickly to provide relief to healthcare providers that have been on the front lines of the pandemic, to provide maximum flexibility under the laws, and to provide funding, which at times has been described as no strings attached funding. But as we all know, there are limits on the regulatory relief, and there are strings attached to the funding. So understanding the limits and obligations is really critical to avoiding legal peril in the future. So the CARES Act was the third major legislative initiative passed by this Congress to address COVID-19. And of the 4 packages passed, it typically gets the most attention because its size dwarfs its other 3 siblings in terms of spending. It includes roughly $2 trillion in new spending. And much of this new discretionary spending flows through HHS. So if you're following along on the slides, there's a non-exhaustive list of some of the new discretionary spending. And I'm going to focus my remarks on the largest pot of money up there, which is the Provider Relief Fund. The Provider Relief Fund, Congress has thus far appropriated $175 billion, and it's earmarked for providers that provide diagnoses, testing, or care for individuals with COVID-19 and that have incurred COVID-related expenses or lost revenue attributable to the outbreak. The authorizing legislation describes a needs-based allocation system. It envisions providers would apply for the funding. With their application, submit a statement justifying need. HHS would thereafter review the application and award the funding based on need. Notwithstanding these instructions, to set up a needs-based award process, there was a strong desire both among the provider community and among policymakers to get these relief funds out the door very fast. And because setting up a new grant program takes time, HHS decided that the most expeditious way to get the dollars out the door was by assuming that all providers across the country had COVID-related expenses and lost revenue, and awarding funds based on data that HHS already had in-house. And HHS has been paying out these provider relief funds in different tranches. The first tranche of money to flow from the fund was what they've called the general distribution, and this amounted to about $50 billion. These amounts were first paid out to providers based on a provider's share of Medicare fee-for-service reimbursements in 2019. So again, data that HHS had in-house. They didn't need to collect any data from providers. A second round of distributions was based on net patient revenue, and this was designed to get at those providers that perhaps didn't have high Medicare volumes, but nonetheless, experienced expenses and losses on par with some of the higher Medicare volume providers. The goal was to pay every eligible provider an amount that was about 2% of a provider's 2018 net revenue. So again, HHS was assuming that recipients had incurred expenses or lost revenues equaling at least this amount. Another roughly $52 billion of the Provider Relief Fund was allocated for targeted distributions. And these targeted distributions have been directed to providers in areas that are heavily impacted by the COVID-19 outbreak. This is called the high impact distribution, and it's going to hospitals with 100 or more COVID-19 admissions. It's also been directed to rural providers, providers with high Medicaid volumes, and safety net providers. And then HHS has also committed to distribute some portion of the remaining funds to providers who have treated uninsured COVID-19 patients and who come to HHS and request reimbursement for those claims. And these distributions are still ongoing. So who is eligible for these Provider Relief Fund payments? For the general distribution, virtually every provider that was treating patients on or after January 31st, 2020 was eligible, with the exception of those providers that had their Medicare provider agreement terminated, their billing privileges revoked, or happened to be on the OIG's exclusion list. And then for the targeted distributions, the providers have to fall into one of the designated categories and also must have provided services to patients on or after January 31st. 2020. So now to debunk the no strings attached myth, back in early April at a White House briefing, HHS leadership suggested that there are no strings attached. These were called no strings attached payments to providers. But of course, these are taxpayer dollars at play, and there are always going to be strings attached. So keeping these payments means accepting certain terms and conditions. And many providers across the country, once HHS began to pay these amounts out, woke up one morning to find money deposited in the bank account. Thereafter, there was a process where providers who had received money and that wanted to keep the money had to attest to compliance with the terms and conditions, which HHS thereafter posted. So these terms and conditions are roughly the same for all of the Provider Relief Fund distributions, both the general and the targeted. Among other terms, the law requires that any provider receiving more than $150,000 in total aid submit detailed quarterly reports to both HHS and the Pandemic Response Accountability Committee regarding the amount of funds received and how those funds were spent. And there are additional requirements on kind of what data elements need to be in those reports. And then all providers who are receiving funds are expected to maintain appropriate records and cost documentation in accordance with Hhs Cost Principles, which, as Chelsea explained earlier, are similar to the FAR Part 31 Cost Principles. Providers accepting funding must also make certain certifications. For instance, acceptance of the terms and conditions means an entity is certifying that the payment that they receive from the Provider Relief Fund will only be used to prevent, prepare for, and respond to coronavirus, and that the payment shall reimburse the recipient only for healthcare-related expenses or lost revenues that are attributable to coronavirus. Providers are also going to have to certify that they're not going to use the payments to reimburse expenses or losses that are reimbursable from some other source. So providers are going to have to be prepared to submit documents that substantiate where those funds were used and how those link to increased healthcare-related expenses or lost revenue attributable to the coronavirus, and also that those expenses or losses were not reimbursed by other means. So knowing what HHS considers a reimbursable expense and how it defines lost revenue is really important. And to that end, a lot of recipients of the funds have been asking a lot of questions. And HHS has really tried to provide guidance on a rolling basis, including guidance on which expenses it considers eligible for reimbursement and how it is defining lost revenues. So there is a FAQ document that's on the Provider Relief Fund page on the HHS website, and they are constantly updating that with further clarifications in an effort to respond to the many, many questions that are coming in. Another certification providers must make is the No Surprise Billing certification. So per this provision, a provider who treats a presumptive or actual case of COVID-19 agrees not to collect from the patient out-of-pocket expenses in an amount greater than what the patient would have otherwise been required to pay if the care had been provided by an in-network provider. So this is a certification that is not found anywhere in the authorizing legislation. However, this represents a really important policy priority of this administration, trying to curb the practice of surprise billing. So this is getting at a situation where a patient comes in, has a presumptive or actual case of COVID-19, and one of the providers treating them does not have a contract with that patient's insurance plan. So in those circumstances, the out-of-network provider must discern what a patient's cost sharing would have been and attempt to collect no more than that amount. So again, as true with any of these certifications, it's important to understand what the agency expects. So the agency has tried to provide additional clarification on this surprise billing prohibition in its FAQs. It's, in my opinion, still not entirely clear, what HHS expects providers to do to discern what's the right amount or what is the cap on what they can charge the patient. So, providers are really going to have to apply a good faith interpretation, document what that interpretation is, and apply it consistently, and consider whether it's appropriate to seek further guidance from the agency. So why is this documentation so critically important? Well, this is a massive amount of money paid out over a very short period of time with relatively few checks and balances. So there's going to be significant oversight for years to come. And as Bob will discuss shortly, some False Claims Act activity as well. So some of these oversight activities are already underway. Congressional leaders are pressing HHS for more data on where the dollars have been going, not only provider relief, some of the Medicare advance payments or the loans that have been going out under a different authority. The OIG has also started auditing HHS's procedures around that initial $500 billion distribution to determine whether the department acted in accordance with the instructions that Congress had given them. And OIG is, very much expected to conduct audits of recipients of the fund, so individual providers and states. That is what the OIG was originally invented to do, was to review program funding, identify instances of fraud, waste, and abuse. So having practices and compliance policies now will, of course, pay off later when, if and when the OIG comes knocking. And I want to touch very briefly on another form of provider relief, a non-financial form of relief that has been given in response to the pandemic, and that is regulatory relief. So, of course, healthcare is one of the most regulated industries in the U.S. The rules are complex and they're frequently changing. And in a public health emergency, the really tight regulatory web makes it hard for healthcare providers to be nimble. So, recognizing this a long time ago, Congress gave HHS the authority to waive certain Medicare and Medicaid and HIPAA requirements during a public health emergency, with the goal of ensuring that patients have access to care and that providers are not penalized for, good faith non-compliance. So the Centers for Medicare and Medicaid Services, CMS, which is the HHS agency responsible for implementing these authorities, has issued a number of what they're calling blanket waivers. And providers acting in conformance with the waiver terms can escape liability for conduct that might otherwise be a regulatory breach. But because these are blanket waivers, they are not issued to a specific party. So again, if you want to take advantage of a blanket waiver, there's going to be, the burden of proof is going to be on you to explain, why the waiver applies to the conduct and why the conduct conformed to whatever parameters CMS put into that waiver. And one of the biggest areas of liability for physicians and healthcare entities that fall within this waiver authority is the Physician Self-Referral Law, or the Stark Law. So in really general terms, the Stark Law broadly prohibits payments for claims that may be tainted by a physician's financial conflict of interest. So referrals to an entity where the physician or the physician's family member has a ownership interest or a or compensation arrangement. There are a number of exceptions to this broad prohibition, each of them themselves complex, and the Stark Law is notorious as a minefield for the healthcare industry. It is strict liability, and there's the potential for huge penalties because violation of the Stark Law or failing to meet an exception means that no payment shall be made. And if you're non-compliant for a large amount of claims, that could result in a very recoupment. It broadly reaches even the most common relationships that physicians have with other providers. And again, as I mentioned, the exceptions are complex and oftentimes ambiguous. So against this backdrop, the waivers of sanctions for noncompliance with Stark Law have been, I think, welcomed by the provider community. They're not perfect, probably not as broad as many would have liked, but that they are certainly welcome relief. So CMS, pretty early on in its response to the pandemic, issued a blanket waiver for the Stark Law, which is retroactive to March 1, 2020. It applies nationwide, and it will remain in effect for the duration of the public health emergency. Importantly, the waiver does not suspend application of the Stark Law. It just temporarily exempts parties from sanctions for certain referrals and resultant claims that would otherwise be impermissible under the law. And again, as I mentioned before, a party relying on a blanket waiver is going to have the burden of proof should conduct be later reviewed by federal regulators. So it's imperative that parties utilizing the blanket waivers make records relating to their use and be prepared to explain how a particular use was solely related to a COVID purpose. That's one really important limitation on the application of these waivers. The conduct has to be solely related to a COVID purpose. And what that means has been the subject of much discussion. CMS did come out with some additional guidance on it last month to provide a little bit more color about what they meant by that. But I mean, I think there's still going to be questions that the agency might need to answer. So with that, I will wrap up and turn it over to Jeff.
Great. Thank you very much, Kelly. I'm going to spend a couple minutes talking about audits, oversight, kind of circling back to some of the issues that Chelsea brought up with the Hhs cost requirements and how it is similar or essentially almost the same as FAR Part 31. One place where I wanted to start is, what is CARE similar to? Based off of our experience, how the law was written and how is it going to be viewed based from a historical lens. What type of audit, what type of oversight will be done. And what we found out is essentially CARES is in some ways based on what TARP was. And TARP is the Trouble Asset Relief Program. TARP was put into place in 2008 to address the subprime mortgage crisis. Originally, they authorized roughly $700 billion of expenditures, and that was later reduced in the Dodd-Frank Act to roughly $475 billion, of which I believe roughly $450 or so billion were actually expended. And that produced a lot of oversight in investigations, convictions, and amounts that were refunds or penalties by the government. So what is the similarities? And I have it here on the slide 54. And the CARES Act, you have the Pandemic Response Accountability Committee, you have the Congressional Oversight Commission, and the Special Investigator General for Pandemic Recovery. Very similar. TARP had three bodies that oversaw the funds. The requirements, which I mentioned on the bottom of the slide, are similar into how you're going to account for the cost, how they're going to be audited, what is the management, the public administration, and then the investigative body. And we foresee the government's going to follow, whether it be the OIG or the SIGP, SIGPR, the same protocols and investigations that we've seen and we at Kenrich have worked on in the past as it relates to TARP. One thing to note is in TARP, I believe there are roughly 300 convictions for wrongdoings, and over $11 billion were ultimately identified as misspent funds that had to be repaid to the U.S. government. So what's going to help companies in determining how the funds were spent, how the government in either the DCAA or the OIG or whatever body is ultimately auditing the funds, is what is it allowable? Chelsea referenced this earlier, as did Kelly. It's not were the funds spent, as you'd see in a non-government contract. Were they incurred? It's did they meet the definition of allowability? And the Hhs Cost Principles is very similar to FAR 31-201-2, determining allowability. So to determine allowability, you need to meet all 5 requirements that are listed on slide 55. The 2 that we typically focus on the most is reasonableness. Number 1, not what was the cost incurred, is what would a reasonable party pay that amount. So documenting why those costs are reasonable is a key thing for all contractors to keep in mind. And then the second being allocability. Is it relating to that contract? Is it related to the loan? Can you truly prove that those costs that were incurred were for that particular grant or for that particular contract? And then obviously you need to follow with the terms of contracts and be generally accepted accounting principles. So this is where companies we work with the most that don't do a lot of work with the federal government kind of run into trouble. They view from an accounting side of the cost was incurred, I have the receipt, I have the invoice, I have proof of payment, so therefore I should be reimbursed by the government. And reminding them and educating all parties that allowability is a standard, not incurrence, is very important. So truthful cost or pricing data, which is historically referred to as TINA, and we're all on the call most comfortable saying and used to saying as TINA, derives from FAR Part 15.4, which the purpose of this is when you're negotiating a price between the government and a contractor, you want it to be an even playing field. You want the contractor and the government to have the same information so they can come to an agreement on what is a reasonable price for a good and service. There is no limitation on what's your profit or what the price can be. You're just required to provide what is deemed current, accurate, and complete. And all your decisions and the accounting information, the build-up of your basis of estimates, is required to be turned over to the government before you negotiate a final price. What's significant here is later on in the contract, if it's found out that the government relied on defective cost or pricing data, there can be downward price adjustments to the contract, and then also additional potential investigations and other investigative activities. Keep in mind that TINA is a disclosure statute, and as I referenced, it doesn't limit price or fee on any contract, but it is a way to ensure that when companies are finalizing prices, that the U.S. taxpayers know all the ins and outs of how those prices were determined. So keep that in mind when you're working with the federal government and they're asking for what is deemed current, accurate, complete, the reasons why they're asking for it. FAR 31-201-2D is from a auditor standpoint, and what we at Kenrich run into the most after the fact, when the costs have been incurred, where the OIG or the DCA questions costs. So these costs may have been incurred, and the contractor may have deemed they were allowable, but they didn't document and maintain records. This is critical for demonstrating that you're spending 60% on payroll, for example. The types of documents you're going to want to maintain, Chelsea alluded to earlier in this presentation, timesheets, proving where the costs are and the times being recorded. It is the contractor's responsibility to demonstrate that the costs are allowable. It's not the inverse. It's not the government's responsibility to prove they're not allowable. The responsibility resides on the contractor. So keep that in mind, because most of the investigations and audits come well after the fact. And you may have turnover at your buyers at the lower levels or mid-levels without your company, and people don't know where documents are. People don't have the purchasing files that demonstrate what you deemed and how you deemed your subcontractor costs were allowable, or how you deemed the 60% was spent on payroll. How did you do those calculations? If you didn't document it, it didn't happen. And there you go, in bold letters. If it's not documented, it didn't happen. You can tell the auditors, the OIG, this is what I did, this is what my company did, this is how we determined it, this is how we determined they were allowable. And the first question the DCA or the OIG will say is, great, can you show me the document that demonstrates how you determine that? And if you cannot do that, the OIG or the DCA will assume it didn't happen and will rely upon the FAR 31-201 clause that I just referenced and may question that this cost is not allowable. So what types of audits and oversight may companies encounter with the CARES Act or generally with government contracting, procurement in general? Most contracts and grants will have various audit provisions that will allow the government to come in after the fact and investigate were the amounts reasonably charged? Were the taxpayers' funds spent properly? And they'll investigate the billing rates. How are the billing rates determined? Your indirect cost rates, your G&A, your overhead, are they reasonable? Are there no unallowable costs? Like Chelsea referenced earlier, alcohol, that's a strictly unallowable cost. You want to make sure that those types of costs are not included in your overhead base. So there is a lot of audit and oversight that comes with receiving federal contracts. So setting things up in the beginning before you start working on those programs is going to allow for a smoother and less question cost audit down the road. So if you're a mid-size or a larger company, what types of systems are typically audited? And the quick answer is all of them. Whether it be your purchase system, how the company is acquiring goods, how they're making decisions on what subcontractors to use, to your labor system, how you're recording your time, how's your payroll recorded, how's your labor talk to your billing system, all the way at the bottom to your estimating system. How are you estimating how you're going to do future work? Every aspect of your accounting system, your purchase system, your estimating system, what I would deem is kind of the backbone of any company, of how they perform their business in the federal space. If you have the relevant audit provisions in your contracts, are fair game. And they're fair game to ensure the taxpayers, and they're often used to ensure that the companies are compliant with the contractual requirements they signed up for, and that the costs are allowable that are being billed, and if there is any wrongdoing, to notify the relevant investigative authorities that they found, whether it be the OIG or the DCAA or another investigative body, that there may be a potential red flag or an issue that could launch into an investigation. So before we get into investigation, how do you avoid or mitigate these types of bad outcomes? It goes back to understanding to the best of your ability of what you're signing up for, documenting the decisions you made from a pricing standpoint, from a methodology standpoint, from a basis of estimates. Remembering where you file all this information away, because these audits may come years after the fact. Our work with TARP, some were 8 or 9 years after a lot of these loans were given to various banks. So it comes a long way, and memories are short. So document. That'd be kind of my closing recommendations from an audit standpoint, is always document, understand what you're signing up for, and the better compliance systems you have, the less audit issues you will have later on, for whether it be question costs or ultimate investigations. And that's all I have for oversight. I think Mr. Bob Huffman is going to talk about investigations next.
Thank you, Jeff. This is Bob Huffman, and I'm going to wrap up the presentation by talking about False Claims Act considerations surrounding all the various aspects of COVID-19 relief and claims and requirements that we've been talking about so far. Before I get into a discussion of the particular risks that COVID-19 funding brings, just a quick review of the False Claims Act, which of course precedes COVID by quite a bit. It goes back to the Civil War. Two things to bear in mind as we look at what are the elements of a False Claims Act violation, which is a civil violation, it's a civil statute. You have to have a claim, which is a request for payment, or what's sometimes called a reverse claim, which is an obligation to pay the government or credit the government, which you have failed to do. If you don't have a claim, it's very hard to see how you're going to have a False Claims Act violation. Another element that's very important is materiality, made very important recently by the Supreme Court's decision in the Escobar case. And I have included some slides that my partner Robert Salcido presented about the Escobar case, particularly with respect to its more demanding materiality requirement for a False Claims Act violation, and they are at the end of this presentation. I'm not actually going to cover them because I want to get, as soon as we can, I want to get to the particular risks that the COVID funding creates. Please bear in mind that the False Claims Act, if a violation is established by preponderance of the evidence, then the defendant is liable for 3 times the amount of any damages sustained by the government and civil penalties between now $11,665 and $23,331 per false claim. And so when you're talking about healthcare providers in particular, you can run up a lot of false claims very quickly. And penalties can be imposed even if there are no actual damages. It's also important to bear in mind that not only the government can bring a Civil False Claims Act case, but also they can be brought pretty much by anybody in the name of the government. These kinds of suits are called qui tam suits, and they can be pursued by the individual or organization, whoever the qui tam relator is, even if the government decides not to intervene. Only if the government actually moves to dismiss the case can it prevent the relator from going forward, and that assumes the court agrees. The relator shares in the recovery depending the percentage depends on how much, whether the government intervenes. So let's focus on what are the particular False Claims Act risk areas that are presented by the COVID-19 statutes, regulations, funding, and requirements. Well, first is the ambiguous and shifting nature of these requirements. I don't need to go into that. I think you've already heard quite a bit, whether it's the PPP program or the healthcare provider program, Main Street funding, whatever it is. There are new eligibility requirements and other requirements applicable to how the money is to be spent, you need to comply with those requirements to avoid a False Claims Act violation. There are the particular new COVID-related certifications and representations that had been previously discussed that need to be, particular attention needs to be paid to whether those are accurate and complete before they're made. There are some safe harbor, hold harmless protections that have been discussed, but they are limited. I think Kelly in particular went into the limitations applicable to the ones in the healthcare provider area. There's a danger to companies in this area from ineffective compliance programs that haven't been updated to deal with new requirements or that have other outdated or limited disclosure and whistleblower type provisions, protecting whistleblowers against retaliation and that kind of thing. Inadequate due diligence, particularly with respect to the funding certifications and representations. Inadequate documentation, we've been covering that in the last hour. And then it's important to remember the heightened attention and oversight that is already being paid and will continue to be paid to the recipients of COVID-19 funding. I noticed a headline that said that HHS had funneled $50 billion in COVID relief to companies accused of Medicare and Medicaid fraud. So that is the way that a lot of these funding programs are going to be portrayed in the press and in Congress and other places. So what can you do about these heightened FCA risks? It's very important to understand and monitor the changing statutory and regulatory requirements. That should be a key component of your compliance program and your training. It's important to exercise due diligence surrounding certifications and representations, even if there is some hold harmless provision for a lender, for example, under PPP, for relying on the certification of the applicant for the loan. That hold harmless may not prevent a key TAM relator from bringing a suit, might not even prevent the Department of Justice from bringing a suit. All it may do is keep the Small Business Administration from auditing you. That's really the third point, understanding the limitations on these kinds of protections. It's very important to assess and upgrade your corporate compliance program to make sure that you're not in a position down the road of saying, oh, yeah, we didn't really have anything dealing with these new requirements in the program, or these particular red flags that could come up. And as has already been stated, it's important to ensure adequate documentation of key interpretations and decisions made with respect to this funding in these programs. This is a little more detail regarding the importance of documenting agency guidance that you may be relying on. It's not simply enough to say, oh, there's agency guidance out there. You really need to document your reliance on it, which means the details of what was said and who said it and when it was said. This is a continuation of that point, and it's a very, very important point in the False Claims Act area. It is a defense, not a complete defense, but a relevant defense to a charge of knowing false claim that the regulations were ambiguous, but you need to show that you tried as best you could in good faith to come up with a reasonable interpretation and to run that past the agency, or at least to make sure there was no agency guidance waving you away from your interpretation. It's important to bear in mind in dealing in this area with federal funding that you, as part of your compliance program, make sure that people understand the importance of staying away from certain statements and emails, even if they can't stay away from emails directly. And statements like these, or it's good enough for government work, or the Navy will never find out, that kind of stuff is deadly when it comes to the investigation and the government's decision to intervene, let alone a trial. These are just some examples of the certifications that can cause a problem and need to be paid very close attention to. And I think rather than going through the remainder of the slides, particularly the Escobar slides, I will now turn it back for the final closeout and the accreditation information. Thank you.
Thank you very much, Bob. This is Angela Stiles again. I want to thank everybody for joining us today. Again, if you have any questions that you'd like to ask, please feel free to email or call us. Thank you and have a good day.